Do you smoke pot? Do you have a kid? Is your kid affected by your marijuana use? What if you're using medical marijuana? Does that make a difference? What if it's prescribed by a doctor? What if you have a hot screen and it's illegal in your state? Is that going to affect your parenting time? Well, it might. And here's the situation. If a judge orders you to take a drug screen and it comes back hot for marijuana, and all other factors have you and the other parent equal, then yeah, it might have an effect because the judge may take that into consideration in determining who gets custody or what kind of parenting time a parent gets. But I had a judge tell me not too long ago, if we took away all the kids from parents who smoke pot, then half the kids in the county would be taken away. And what he meant by that was, although it may be a big deal, it's just not a big enough deal to take kids away from parents. So it may have an effect, but probably not. What do you think about that? Roger had a girlfriend, and that was a good thing because Roger wasn't really that good looking, except for the fact that Roger also had a wife. Well, Roger had bought his girlfriend a $10,000 Rolex watch, put it on her wrist. Wife found out about it. Don't know if she found the receipt or how she found out about it, but she found out about it and was not too happy. She filed for divorce, and in the divorce, she wanted the full value of that Rolex watch. She actually wanted the Rolex watch ripped off the girlfriend's wrist and put on hers, but that wasn't going to happen, so she wanted the full value, $10,000, in the divorce. Well, the judge heard the case, and he ruled that she only gets $5,000 because the full value of the watch would be marital property, $10,000. $5,000 would go to him, $5,000 would go to her. And that's what happens in these situations. The judge will always value whatever the property is that was wasted by the other spouse and take half of it and give it to the other spouse. And that's what happened in this case. You got married 20 years ago, but you separated about 15 years ago. You have no clue whatsoever where your spouse is located. They just simply disappeared and you hadn't seen them since. You don't even know if they're dead or alive. But you want to get divorced. You want to move on with your life. It's been too long. What do? Well, in Tennessee, as in most other states, you can publish notice of the divorce. In other words, you can put it in the paper and let it run for a period of time, and then that person is considered to have received notice and they must come forward and defend the lawsuit. And if they don't, you can go ahead and get a divorce. The problem is you have to make a diligent search and inquiry before you can do that. That means you have to contact relatives, former employers, send letters to their last known address, try everything you can and exhaust all possibilities of finding them. Then if you can't, you can get the court to order the paper to publish notice, and that serves as effective service of process for the divorce. Hot booty cutie. You should have seen the look on that 75-year-old judge's face when he heard that. You know what that was? That was my client's email address, hot booty cutie. She did have a hot booty and she was a cutie, but that was kind of lost on that 75-year-old judge. Here's the point. If you've got an email address that's anything but your name and some numbers after it, and you got a court case coming up, you might want to change your email address. Because when those emails get introduced into evidence, one of the first questions the opposing attorney is going to ask is your email address such and such? And if it's something inflammatory, you better change it, because judges are human. They hear those things and it makes an impression, maybe subconscious, but it's an impression. So keep in mind that if you're ever going to go to court, you want to keep it as calm and even-keeled as you possibly can. So if you've got some strange email address, change it. Change it before you go to court. Hey, if you're under 18, listen up. Can you be emancipated? Can you have the disability of minority removed so that you can be treated as an adult legally? The answer is yes in Tennessee, but it's difficult. Usually we only see that when a child's parents have died and they're old enough to take care of themselves and they don't have anybody else to help raise them. What you have to do is you have to petition the court. And if your parents are still living, you got to let them know. They have an opportunity to come in and contest it. Even if your parents aren't living, you may have a grandparent or aunt or uncle that's living and they can come in and contest it. It's unusual, like I said. It's also costly, time consuming. You have to have a good, legitimate reason, and you have to be mature enough to be able to take care of yourself. The court can also remove a disability of minority for a specific purpose. I had a girl one time that got a personal injury settlement. The court was holding her settlement. She wanted it to buy a car. She was 16 years old. The court removed her disability of minority to allow her to buy a car. That's unusual, but it does happen and you can do it. This goes under the category of sometimes it's better just to keep your mouth shut and take your medicine. I was in the rehearing section or rehearing docket of child support court the other day. It's where a judge hears a case a second time after a magistrate's already made a ruling. If one of the parties is dissatisfied with what happened before the magistrate, they can ask a judge to hear it, a new judge, and that judge will consider it again and make a new ruling. Problem is, it takes about 6 to 9 months to get into that court, that rehearing court. Well, this one guy was in there representing himself, and I was sitting there waiting for my turn, and I was listening to the guy up there, and the judge looked down at him and said, "Sir, are you sure you want to go forward with this rehearing, or you just want to be satisfied with what the magistrate did?" Turns out the magistrate had set child support at about $450. Problem was, that was about 6 or 7 months ago. He had a new job now making more money. He wanted his day in court a second time, and he got it. Judge raised his child support to $600. Sometimes it's better to keep your mouth shut and just take your medicine.